Hello and welcome to Center Spotlight. I'm Patricia Quirk, the Marketing Coordinator for the Dale Association. And with me today is Linda Grear, an attorney with HoganWillig Attorneys. Welcome.
Good morning. Thank you very much for having me.
Thank you for joining me. We're going to talk about a few things today, but I wanted to ask you first to tell us how long have you been an attorney, how long have you been with HoganWillig, and what kinds of law do you like to practice?
I have been an attorney for approximately 14 to 15 years, and I've been with the law firm of HoganWillig for approximately 7.5 years. I concentrate most of my areas of practice in the areas of elder law, estate planning, and guardianships. And I've been doing that type of law for probably about 13 years.
So you must like it.
I do enjoy it very much.
Wonderful. Tell us about this estate planning. Are there some specific things that everybody should know, regardless of their age?
Yeah, actually there are 3 basic documents that all individuals should really consider having in place, and the specific content of those individual documents will vary based upon the individual's financial circumstance, their family situation, and the factual circumstances of their specific case. But the 3 basic documents themselves are first a last will and testament, the second is a power of attorney, and the last is a health care directive. A last will and testament is essentially a list of instructions that you leave to have followed after you've passed away. It doesn't have any legal bearing at all while you're alive, but it's instructions to be followed for a later time following your death. It allows you a couple different opportunities within that document. First and foremost, you may designate who are going to be the beneficiaries to receive the estate after you've passed, how they receive those assets. For example, if you have minor children or grandchildren, you may decide that you don't want them to just inherit that money outright immediately. You may want to restrain it in a trust. Also, if you have an individual that would be a beneficiary of your estate that might be under any sort of disability and receiving governmental assistance, you may further want to restrain that in a special kind of trust that will allow them to still get the benefits of the use of the money to improve their quality of life, but will not allow them to lose their governmental assistance.
Right.
So there's a specific type of trust that we could do in a will for an individual like that. Your will also allows you an opportunity to designate an executor, and that's the person that is actually going to wrap up your final affairs. They're going to make sure that all your final bills are paid, make sure that your estate is administered in accordance with the will that you have left. Again, in your specific family circumstance or financial circumstance, there may be a different type of will. We might want to do some credit shelter planning for estate tax purposes. But that's the basic framework of what a last will and testament would be.
Okay, and so now the executor of the will, obviously you'd need to speak with this person ahead of time.
You should. It's
so that they're prepared and okay with this responsibility.
Absolutely. It is a big responsibility, and you also want to pick someone that's going to be mature and responsible, good with paperwork, somewhat organized. It doesn't have to be anybody that has any specific training. They don't need to be a CPA or an attorney or anything like that. Any individual can do it, but you want to pick someone that's going to be responsible and also take into consideration the family dynamic. You want to pick someone that's going to be able to work well with your beneficiaries and be able to get the job done for you.
And maybe a backup executor? Do you have executors in waiting?
Yeah, they're actually called alternate or standbys, and yeah, you absolutely I would normally recommend that having at least one standby in place, not only for your executor, but should you choose to do a trust for a child or a minor or disabled individual, you would want to have a backup alternate trustee for them as well.
Okay.
So it's definitely recommended to do it that way.
Okay, so we've talked about the last will and testament. You mentioned a durable power of attorney. Now, I have one of these for my own mother. My siblings and I went into this agreement about 1.5 years ago. Tell the viewers why this is important.
It's very important not only for people that are older, but people even that are younger. So for ourselves, I have one for myself, my husband has one as well. They are important documents to make sure that if something catastrophic happens to you and you're alive, but you're unable to handle your own affairs, that someone can step right in and take care of things such as paying your bills, dealing with your insurance companies, dealing with Social Security, making sure your assets are marshaled and protected. If you don't have something like that in place and a catastrophe happens, something catastrophic like a car accident, or you have an unexpected stroke or a heart attack, if nothing's in place, then your family is forced to do a guardianship proceeding, which is a court proceeding, generally in Supreme Court, can be somewhat costly and take some time, and you can avoid it by simply just doing a simple document known as a durable power of attorney. Again, you're allowed to appoint an individual. You can have backups. State law also allows you to have more than one person working at any one time. You could also do the same on an executor on your will. You can have more than one person at any given time doing things for you. It allows some flexibility, but a very important document to have in place. That power of attorney basically is effective when you sign it, and it remains in effect until you pass away. Unless you decide that you want to revoke it, if there's a circumstance that changes in your family and you decide you want to revoke it, you can do that too.
And in our case, we also utilized it for real estate sales.
Yes, you can do
so
that.
Sure.
As a matter of convenience, you can certainly use it because it's effective right away, even though your mom may still have capacity, and it's just that she doesn't want to have to deal with going to the courthouse and signing things or the clerk's office. You could use the power of attorney to help her with that.
Right. Okay, and then the last one was the healthcare proxy or living will.
Right. New York state law allows basically two types of healthcare directives. One is a healthcare proxy, and the other is a living will. In our office, we actually combine those two documents into one, generally speaking, for most people. But a healthcare proxy is a document where you will appoint someone to make your healthcare decisions for you in the event that you're not able to communicate to your doctors. And you need to keep in mind that the doctors are always going to be dealing directly with you first and foremost. So as long as you can speak with them, they're going to talk to you.
And their goal is to keep you alive and keep you healthy.
Well, that is the physician's goal, of course.
Right.
Yes,
so that's
absolutely.
why it's important. Like you said, if something happens and you can't communicate, you need to know that there's a responsible person, an adult, who knows your wishes.
Absolutely, and you can also
act on
specify what your wishes are. And that's what a living will does. Basically, the healthcare proxy is where you appoint someone to serve as your proxy or your agent. Now, under New York state law, you can only have one proxy at a time, but you may name backups or standbys. So you can have first choice, second choice, third choice. And then it allows you also to go one step further and do a living will that says, I've appointed my daughter or my son to be my agent, and my daughter or son knows what I want, but I'm also telling my physicians, if I were in a coma or a persistent vegetative state, I would not want feeding tubes. Or maybe you would. It really depends on what your personal feelings are, what your faith might be. Every person is different. We can't make that decision for you. And that's really why it's important to put it in writing so that everybody is aware of what your wishes are.
Now.
Now,
right? Put it in writing now.
Exactly, and you don't want people fighting about it later. This actually became quite a popular topic in the last few years. Several years ago, there was a woman down in Florida by the name of Terry Schiavo.
I remember that case.
And there was a family battle about whether or not life support should be continued or not. And whether you have a belief one way or another, it really doesn't matter. But the fact of the matter was that she could have avoided, that family could have avoided that dispute had Terry put something into writing before the catastrophe happened to her. So put it in writing. It saves a lot of headaches, family squabbles, and emotional stress for people too.
Sure.
If you put yourself in a situation of a child that has to make that decision, or even a spouse that's making that decision, it will be a lot easier for them to see in writing that this is what mom or dad wanted, and it's going to be easier for me to make that choice,
Sure.
whatever the choice might be.
Well, that's a good point. Now, before